Public and constitutional law is about power. Who can exercise power, what types of power can be exercised, and whether and to what extent there are any limits on the exercise of government power. At the beginning of the course, we'll look at the origins of Canada's legal system, and we'll look at how it was influenced by the French and the United Kingdom systems of government. We'll also look at how the Supreme Court of Canada has recognized Aboriginal law within the Canadian constitutional framework. We'll look at the Constitution Act 1867, which established Canada as a self-governing dominion, and that divided the authority to make laws between the federal parliament and the provincial legislatures. We'll look at Canada's constitutional development from 1867 to the present, and how Canada gained autonomy from the United Kingdom. A critical moment in Canada's constitutional development was the enactment of the Constitution Act 1982. This famously included the Canadian Charter of Rights and Freedoms, but it also included the constitutional amending procedures. Until 1982, if Canada wanted to amend its constitution, it almost always had to ask the United Kingdom to do this on Canada's behalf. The Constitution Act 1982 enacted 5 procedures so that Canada could amend its own constitution. It also famously included the Charter of Rights and Freedoms. We'll look at many of those rights in the course. For example, we'll look at how the Supreme Court has interpreted the right to freedom of expression, freedom of association, the right to life, liberty, and security of the person, and the right to equality. We'll also look at the role of Parliament and the provincial legislatures in setting reasonable limits on charter rights. And we'll look at the ability of Parliament and the legislatures to enact laws notwithstanding certain charter rights. The middle part of the course will examine the 3 branches of government. We'll look at the executive branch of government, including the formal executive, consisting of the Queen, the Governor-General, the Lieutenant Governors, and the Privy Council, and also the political executive, consisting of ministers and the Cabinet. Next, we'll look at the legislative branch of government. We'll look at Parliament and the legislatures and the lawmaking process, and we'll also look at the role of parliamentarians in deliberating and holding the government to account. To conclude the middle part of the course, we'll look at the judicial branch of government. We'll examine the structure of the court system in Canada and the way that judges are appointed and removed from office. We'll also look at how the Supreme Court of Canada has elaborated protections for the independence of judges from undue influence from the other branches of government. The last part of the course, we'll look at the interaction among the 3 branches of government. So, we'll look at how judges examine laws to see whether they're consistent with the Constitution. We'll look at how judges supervise the exercise of executive power, an area of law known as administrative law. And finally, we'll look at the techniques that judges use to interpret statutes. Many of the techniques of statutory interpretation are technical and depend on the meaning of words, but we'll look at a broader question about whether judges should only look at the words enacted by Parliament, or if they should also try and discern the intentions of Parliament or the legislatures.